Supreme Court of the State of Nevada is now in session. The Honorable Chief Justice Perryberry presides.
Good morning. Go ahead and be seated. Okay, the first matter we've got on this morning is docket number 67490, Holyoak versus Holyoak. Mr. Beller, are you ready to proceed?
Yes, Your Honor. When this matter first came up, I thought it was a relatively clean-cut, clear situation. And we are almost a year later, and it is far from clean-cut. I think the law on this, whether it be NRS .6703 and .155, clearly lay out what a district court judge can do, i.e., in terms of 6703, describing what a decree can say or what can be done, which is not, in my opinion, contrary to NRS .155, saying when the court may make a disposition of the retirement benefits before the date that the party actually retires. I do not believe those two sections, those two NRSs are contradictory. I believe one flows from the other. There clearly are four cases in this particular matter that define effectively eligibility to retire and versus at the time of the decree of divorce. I also recognize that, at least it seems to me, that this case is the culmination of NRS sections as well as the case law in terms of what this court is going to do. This matter was mediated before Judge Gaston, and effectively, we all know, at least those of us that have been around a while, and there are a number of us that have been. I mean, Judge Gaston was an educator, a legislator, a family court judge, and then got back into mediation. I think this is important because we're dealing with what this court is going to do vis-a-vis the overall situation, and then specifically what Judge Ochoa decided, which I believe respectfully he erred in saying that this is not what the parties intended. Again, Judge Gaston wrote that mediation brief, and that was incorporated into the effective decree of divorce that was signed off by Judge Hardcastle. In the Judge Hardcastle actually decree, there was additional language in there where Mr. Holyoak, retired now from Metro, paid an additional amount of money to Tony Holyoak for the provision, and there is an affidavit and declaration by Eric Holyoak basically saying that he will pay that amount of money again when he retires. He retired in 08, and or they got a divorce, I'm sorry, in 08. He retired last year. Judge Ochoa basically then concluded that notwithstanding the language, effectively the intent of the parties was consistent with case law, the four cases, without belaboring them, in terms of eligibility to retire, notwithstanding the language of the Memorandum of Understanding and the Decree of Divorce, which incorporated the Memorandum of Understanding. And
Mr.
that
Beller,
basically said at the time of retirement.
Could I interrupt your
Yes, Your Honor.
argument
Sorry.
a moment? To be clear, is it your argument that the reference in the affidavit is that Mr. Holyoak paid an amount that would account for the community property share of her interest in the retirement fund from the time of the divorce to the time he ultimately retired. Is that your
No, that is
contention?
not my argument, Justice.
Then I'd like you to clarify what you just
Okay,
said.
my argument is that pursuant to the decree of divorce, there was an additional $20,000 that was paid by Eric Holyoak to Tonya Holyoak in order to have this global gestalt, if you will, settlement. Again, neither party was represented by counsel, and it was before Judge Gaston in terms of going from room to room and then incorporating what the parties basically agreed to. Again, I comment on Judge Gaston because of his background as an educator, as a legislator, as a family court judge. To me, it says at the time the parties retire. I don't think, notwithstanding what Judge Ochoa said, the parties must have really intended to mean eligibility to retire. I don't think that's what it says, Justice. It says what it says, and notwithstanding the parties were not represented by counsel, they actually were by former Judge Gaston in terms of memorializing what the parties said. I might also add that
Mr. Beller, where can we find that in the record to substantiate that? Because there's a couple of other references of $20,000, but that's to equalize debt on some other things, so I'm just
in
curious.
the decree of divorce, Justice Douglas, that I believe is part of the record. And that was signed off by Judge Hardcastle at the time.
But other than reflecting the fact that the additional $20,000 or the $20,000 was paid, what it was paid for is not clear. Would you agree?
Yes, I would, Justice.
Okay, all right. So your argument would be that one could characterize it as an offset or on account of the community property interest for those months or years between employment and retirement, or eligibility and retirement, but that's not clear.
That is true, Justice Hardesty, but nevertheless, it is there.
Yeah.
And it was, there was an amended petition, there was a petition, an amended petition, and then ultimately the decree of divorce where it incorporated that language. And I don't believe...
Can I extend your argument then one step further to say there at least appears from your point of view and from your client's point of view to be an unequal distribution of property by virtue of the $20,000 payment, and somebody ought to account for that?
That is exactly my argument, Justice Hardesty. Now, I do recognize that before this court is the gestalt, if you will, argument, and that is whether or not parties can actually bind themselves contractually to an agreement to alter NRS and case law. I believe that's issue number one before this body, and that is why obviously we're having an en banc discussion of this particular issue. The next issue, as far as I'm concerned, is whether or not Judge Ochoa erred in terms of what does it mean? You have a petition, you have an amended petition, you have a decree of divorce, and you have the MOU, and the MOU is operative. I don't know, notwithstanding, even if it's not even, in my opinion, but the point being is there was consideration, and you have to look at basically the parties. I mean, effectively, if one were to adopt, again, in my opinion, Judge Ochoa's logic, it would have to be with specificity what the parties bargained for, what they were giving up, et cetera. And that is basically what he said in terms of the oral argument. Well, if the parties really meant, they would have said X, Y, and Z. Well, again, that's why I have to go back to Judge Gaston in terms of, I don't know what more anyone could say other than at the time the decree, the parties are divorced. I mean, that's as clear, in my opinion, as there are 7 justices sitting before me. I mean, it says what it says. And so Mr. Holyoak bargained for that. Mrs. Holyoak bargained for that. And at this juncture now, to not have the benefit of that bargain, I think is an injustice to Mr. Holyoak. In addition to which, aside from this body deciding this particular issue, we now have ancillary issues.
Mr. Beller, let me go back to this MOU and the $20,000. The only reference to $20,000 I see in here is a reference to him giving her $20,000 to buy out her interest in the home. So I'm sitting here reading it, so I'm looking for that. So if there's someplace in there, if when you're sitting down, you can give it to me, I'd like to have that, because that is troubling.
It is, Justice Douglas, in the decree of divorce.
But it's not in the MOU, and that's the document you're talking about.
Well, unfortunately, Justice, you have 2 pro se litigants going before Judge Gaston.
And that's kind of a concern also. They're pro se litigants. Was there a reading of, I hate to use the term, rights to the parties, understanding you have a right to a percentage of the community assets? You're giving up these rights. You have a right to receive a portion of the retirement at the time the party is eligible to retire, opposed to when they retire, those kind of things. So it's a knowing, I hate to use the term waiver, but waiver of those rights. Or we just have 2 pro se litigants floating out there, and depending upon how this was done, people gave up rights not knowing what they were giving up.
Justice, in my opinion, if they were pro se and they prepared this themselves, that would be one thing. But with former
Irrespective of who was in front of them, do we know that this person explained to them what they were giving up and what their rights were? Because then the concern is, even though it's a memorandum of understanding of this alleged settlement agreement, was it done fairly, openly, and so on, as to be a neutral?
We have an unrefuted declaration by Eric Holyoak, which is part of the record in terms of what occurred. And basically, to follow what the court is suggesting, then the parties could never go before a mediator and resolve, because that's just not the way, in my opinion, the process works.
Could a party go before that party if certain declarations were made as to what they understood or did not understand?
Judge Gaston, having been before him once or twice on these issues, certainly goes into each and all of those things.
But do we have that any place in a record of what he went into?
No, we have what we have with Judge Gaston, Justice. At any rate, it is, again, and I'll be happy to show you, I believe, since I have a couple of minutes.
Mr. Beller, did you want to reserve any time for rebuttal?
Yes.
Okay,
In fact,
you've got
I think
2
I will
minutes
do
and
that.
4
Thank you.
seconds. Okay.
Chief Justice, Justices, Marshal Willick for Tony Holyoak, may it please the Court. The issues actually presented by this appeal are straightforward and simply resolved. But this case also provides the Court an excellent opportunity to address and resolve some inconsistencies and conflicts in its prior cases, which this Court has asked me to bring to its attention. The central tenet of Nevada community property law is that both parties accrue a present, existing, and equal right in all property at the moment of its acquisition, and the full value of all such marital property is to be divided and distributed equally upon divorce between the parties, absent written findings of compelling reasons to do otherwise. That is true for simple assets like cash. It is also true, equally true, for complex assets like non-qualified stock options, or certain kinds of retirement benefits that on their face, by the nature of the asset, are inherently unequal between the parties. It's the task of the divorce court to issue orders that divide those assets and debts as equally as possible between the parties, so the benefits and burdens of the community are equally divided between the parties upon divorce, no matter what kind of assets are involved in the distribution. Keeping this basic principle in mind not only resolves the issues in this case, but also allows the court to resolve the inconsistencies and the conflicts and errors in the prior decisional law. The parties' MOU says that PERS will pay each party their proportionate share. This court has held many times that language means it is a time rule division. A time rule division is a proportionate division. Eric claims that NRS 125.155, which prohibits calculations based on estimated increases, overrides the time rule. As this court correctly held in Henson, that's simply not true. The time rule doesn't estimate anything and doesn't conflict with that statute or any other statute. Eric's main argument is that the one sentence in the MOU addressing the PERS pension was a waiver of both Nevada law and Tony's right to begin receiving payments upon eligibility for retirement. But the trial court looked through the entire record and found no evidence in the record of any intention to do anything but comply with Nevada law, mandating distribution upon eligibility for retirement.
Mr. Willick, are the parties, as asserted by Mr. Beller and as, I guess, enunciated in Rivero, able to contract to different terms if they so choose?
Well, Judge Ochoa found that they could if they wanted to. He found no evidence that there was any intention to do so. But yes, I would suppose that if parties wanted to and they put on the record written findings of compelling reasons for an unequal distribution of property, the statute on its face, 125-150, specifically allows them to distribute property any way they want if they make the appropriate findings. But if, in the absence of those findings, what this court said in Cerdic, clarifying Gemma and Fondi, is that the normal distribution of a spousal share is upon eligibility for retirement. That's what's supposed to be done. That's the rule in every community property state. If a worker does not retire at first eligibility, the worker is to pay the spouse whatever the spouse would have received if the worker did retire at that time. There is no known contrary authority.
With the language, you have a settlement agreement, correct?
Yes.
And the settlement agreement says that the Quadro will direct the trustee of PERS to pay to each party their proportionate share of the account at the time Eric retires.
And that's an entirely correct
Tell me
statement.
what you do with that language, because you agree that parties could contract to a different result than what the court would apply if it were a contested case. They can agree to settle a case on terms acceptable to each of them, and they put this language in their agreement. I'm troubled by it, and I would like to hear from you why that language is not binding.
It is binding, but it's a correct statement of law that has nothing to do with the issue before this court. The trustee of PERS will pay nothing to anybody until Eric actually retires. All that provision says is that upon his actual retirement, the trustee of PERS will pay the proportionate share to each party. It's a true statement. It's incontestable, but it also has nothing to do with the obligation of the employee spouse to make payments by himself, not from PERS.
And where do you find the written statement of that exception? Because
That's not an exception. That's this court's holdings.
where is it written?
Gemma, Fondi, Cerdic, and Wolf. This court has said so 4 times. It is the decisional law of this state, and it's binding on everybody in the absence of an explicit court order to the contrary. That is how it is to be done, absent an explicit contract to the contrary. Judge Ochoa looked for one and couldn't find one, and there isn't one. There's absolutely nothing in this record indicating any contrary intent to do anything other than what's provided by law.
So the language, the Quadro will direct the trustee of PERS to pay, is how you separate the obligation that you believe Mr. Holyoak has to pay at the time of his eligibility.
If there was an intention to override Nevada law, it would have to be specific. A waiver would have to be an intentional relinquishment of a known right, clear on the record. She has a right under this court's authority and under this court's statement of what the time rule means to payment upon eligibility for retirement. If she was going to give up that right, It would have to be explicitly stated on the record. She would have to have a clear understanding and statement of what she was giving up, and she would have to say that she did so knowingly, willingly, and for something. And as Justice Douglas pointed out, the $20,000 is a house balancing. It has nothing to do with anything. They were simply dividing their assets down the middle. When you divide a pension down the middle, you divide it in accordance with the time rule. That's what it means. That's what this court has said it means in cases going back to 1988. That is the standard law. And it does, however, raise the various conflicts that are hidden in the case law that I would like to talk about. There are two primary cases.
Mr. Willick, can I ask you just to clarify this one point, just to say it made? So you believe there's no evidence to show that Mr. Beller's client paid additional consideration to your client for the delay in receiving these pensions?
There is zero evidence.
Okay.
No statement of intent, and no argument was ever made in the district court. That is a new argument heard here today for the first time. That's never even been raised in the district court. The two cases at issue here are Wolf and Henson, and dealing with what they actually say and don't say. There are two cases that they're correct and slightly incorrect as a matter of fact, and that leads to some legal problems. In Wolf, this court held that a wife's share would not revert to the husband, but would be continued to be paid to her estate if she died first, because the divorce decree divided the community property pension into two separate interests, and that the wife's estate would get her interest if she happened to die first. That's the holding, the main holding in Wolf. As a matter of community property theory, that statement is entirely correct. It makes the wife's allocation of the asset in question exactly equal to the husband's allocation of that asset. And in many retirement plans, it's easy to do. In any ERISA-based private retirement, you can easily carve the pension plan into two separate pieces. You can split the pension itself into two parts, one for him and one for her. But just declaring it so, which is what this court did in Wolf, doesn't make it so for all pensions. PERS won't enforce the Wolf holding and believes itself to be immune from any order asking it to do so. And that's because the structure of PERS system, like that of military retirement, doesn't permit the pension itself to be split, but only division of the payment stream. If the spouse dies first, her share of the payment stream automatically reverts to the employee, no matter what the decree says. So the employee has an automatic, cost-free survivorship interest built into the law that automatically restores to him the full amount of the spouse's share if she dies first. But she has no such built-in protection if he should die before she does. She has no protection at all. In states like Nevada and California, the divorce court's duty is to equally divide the benefits and the burdens, which is what Wolf requires. It's exactly the same for complex assets, like PERS retirement benefits, as it is for all other assets. The closest the courts can come to actually balancing the benefits and burdens in dividing an asset like PERS benefits is to provide the spouse with a survivorship interest, so if the husband dies first, she is protected like he is already protected. That's true for any pension, with an automatic reversion of the spousal share to the member employee spouse in the event of death. The California courts resolved this problem 30 years ago. In a series of cases going back 30 years, they're in the materials, they said that all components of a retirement benefit have to be divided equally between the parties in order to make an equal division of a pension. That's essentially what this court attempted to do in Wolf, an actual equal division of the pension. And that's why one small part of Wolf is an error. Specifically, the reversal of the order to provide private insurance for the spousal interest, which the court declared incorrectly as an unequal distribution of debt. The survivorship component of a pension is an extremely valuable component of the pension. Any divorce judgment that allocates a survivorship interest to one party but no survivorship interest to the other party is inherently unequal. The insurance in Wolf simply gave to the wife the same pre-retirement survivor protection that the husband already had by virtue of the system. Under Nevada community property law, the parties should equally share in benefits that cost nothing, and they should equally share in benefits that cost something. When those benefits are being equally divided between the parties, the divorce court must address and divide survivorship interests in order to provide an equal distribution of a pension, because the employee spouse does have a survivorship interest in the life of the non-employee spouse. It simply is a true statement of fact. That's part of the reason the secondary holding in Henson was an error. It contradicts the holding in Wolf, and it causes divorce decrees dividing pensions to be interpreted as not...
Mr. Willick, I appreciate what you're saying, but how does that specifically pertain to the fact scenario in the case presently before us?
Because it's exactly what happened. The judge in this
We have-
case said that Tony Holyoak was entitled to her collection of her share of the pension during her life and after her death. And it reversed that decision after this court issued Henson and the court read the secondary Henson holding. The secondary Henson holding contradicted Wolf and is in error. This decree, like most decrees in Nevada, divides pensions very badly.
But before we even get to that fact, we have to make sure that we're on solid ground as to the basic facts.
All you have is a divorce decree which says divide the pension. And what I'm asking the court to do is to
And
construe.
she's made application once he became eligible.
Yes, and got an order saying that she was entitled to her time rule portion from the moment of eligibility. The question is not so much that. The question that I was just addressing was not that.
I understand the
part.
question you were just addressing, but I'm wondering, do we even need to get there in this particular
You do,
case? Based
because
upon the
the
facts
case
we
you have in front of you is a case where the secondary Henson holding has been applied to create a legal result. If this court chooses not to revisit it, then the court's ruling was entirely correct. But if the court takes up the invitation, which I have been asked to extend, to explain the conflict between the cases, revisits the secondary Henson holding and changes it, then that order was wrong. And on remand, the court should be asked to revisit the orders that it made depending on that ruling and alter it. The reason most pensions are dealt with so badly is that most divorce decrees say only in vague or general or partial language, divide the pension, like this one. And the reason for that is most lawyers don't understand pensions.
Well, I want to
Most-
return to this point because I'm struggling with the question I asked you earlier, and in particular, trying to measure it against 125, 155, 2, which says the court may, in dealing with a pension or retirement benefit, order that the benefit not be paid before the date on which the participating party retires. So I read that, and I understand your point that you're saying, well, this sentence in the private agreement, in the memorandum of understanding, just says, well, you won't get paid by PERS until the guy retires. And that's a legal given. So to me, I'm struggling with the idea in the context of 125, 155, 2, and this language that this payment won't, the proportionate payment will not occur until Eric retires. I'm struggling with why we should not read that as
125
referential to paragraph 2 of 155 and say, this wasn't meant to start until then.
125.155 is permissive. That's what the primary holding in Henson says, and that's an entirely correct holding. And Judge Ochoa specifically found, after looking at the language used in the history of the parties and listening to the parties on the stand and assessing what they said and what they said through their attorneys and personally, that there was no
But if
intention.
you upset one clause of a settlement agreement, then you're opening
no
the
upset.
entire.
There is no upset. Nothing has been contradicted. Nothing has been overridden. It's being completely enforced exactly as written. At the moment of retirement, a quadra was presented to the PERS administrator, and PERS has begun paying the proportionate shares to the parties.
But then you're not directing PERS to do anything. PERS will always pay at the time of retirement, and if there's something that directs a proportionate share payment, they will do that. So that language then becomes pretty much meaningless. It's just
It's not meaningless.
supernumerary.
If it wasn't there, she wouldn't get anything. It had to have a PERS pension division in order for the spouse to get a payment from PERS. That's the only way PERS will accept a PERS quadro.
But it
Is the
didn't
under-
need at the time Eric retires. That language would be meaningless.
It's
That
not
phrase, at the time Eric retires, would be meaningless under your reading legally.
No.
You wouldn't need it. If you didn't have it, what would it be? The quadro will direct the trustee of PERS to pay each party their proportionate share of the account, period. Let's say it said that. That would be
There'd be
implicit.
no difference.
Right, exactly. So if we
question
want to
is
have
whether these
each
two-
phrase, excuse me.
I'm sorry.
If we want to have each phrase have meaning, at the time Eric retires, seems to me it either means something or it doesn't.
May I answer the question?
Yes, please.
The language written by these two proper person parties, one sentence stuck in an MOU with the assistance of a mediator, was not intended to be a technical overriding of any portion of Nevada case law or statutory law. What
Okay,
the
I understand
parties-
that point.
What?
I understand that point.
All
I
the
guess
parties-
you're just saying that it means it just was gratuitous. It wasn't necessary.
Yes, and in looking for fineness in meaning where proper person litigants are trying to divide pensions is a fool's errand. Because in the great majority of divorces, and probably no attorney in the state of Nevada has reviewed more pension division clauses
Right.
in divorces than I have, they are all terrible. They all say the wife will get her proportionate share of the benefit, or the wife will get her time rule share of the benefit, or the wife will get her proper piece of the pension. That's what they say.
But isn't it sort of a slippery slope when we go behind an objective reading of a contractual settlement's terms and start looking behind that and opening it up because one party was pro se or another party was or both were?
You don't have to. I asked the court to do what it said 1988 in Walsh that it would do, and that's to construe every divorce decree in the absence of express language specifying otherwise to be in compliance with state law mandating an equal division of marital assets, and that means, for pension divisions, an equal division of all aspects of the pension, every single component that gives value, balancing the benefits and the burdens equally between the parties. If you do what you said you were going to do in Walsh and construe all language, no matter how terrible it is, as intending to do what the law provides, you will do justice to most people most of the time without accidentally creating injustice by trying to imply an intention to give one party or the other some leg up in the law when nobody in reality was thinking any such thing. That is what the court should do because that is the fair thing to do. It's the just thing to do. It's the equitable thing to do. Divide pensions equally between parties, and that means all of it. So there are 4 holdings, if I can just complete, that I asked this court to make.
I have a question before you.
I'm
do
sorry.
this. Chief, may I pose a question?
I'm sorry.
Mr. Willick, how does the court reach the survivorship concerns that you raise arising out of Wolf and Henson in the absence of a cross appeal in this case?
Because if this
You're
court...
writing an opinion, how does one reach the arguments you're making to correct the language in those 2 cases without a cross appeal?
If this court chooses to not revisit its prior case law and doesn't, the court doesn't need me. This court at any time can decide that it is in error as to a point of law and correct it. And it doesn't make any difference how that is brought to the court's attention. If the court does not choose to revisit the secondary Henson holding, find it in conflict with Wolf and resolve it, then the judge's orders were correct. And no cross appeal would have been appropriate because no cross appeal would have a chance of standing. But if the
I
court...
don't see where Judge Ochoa even addressed the survivorship question. Was that raised to him
Oh,
in
yes,
the district
and he
court?
decided it first one way and then the other way after Henson. If you look through the statement of facts in the answering brief,
Okay.
you'll find the original order which says that she gets her interest regardless of
Mm-hmm.
his life or death, which means a survivorship interest. And then later, after Henson, he called for new briefing, asked for a copy of the opinion,
Mm-hmm.
asked for it to be addressed specifically and for it to be explained to him, and we did so. No filing came in from the other side, but we gave him a briefing on Henson and what it said and what it meant. And after that, he said, well, quoting Henson at length, he said, if it wasn't explicitly stated on the MOU, if counsel didn't have the foresight to think, I'm not only going to divide the lifetime payments, I'm going to divide the survivorship benefits, if those words don't appear in the divorce decree by misadventure or generality or for whatever reason, then she gets nothing. But what that means, and that's the Henson error, is that he gets a survivorship interest and she doesn't. And since there is an underlying factual error in Henson that this court was unaware of because the attorneys who presented the case were unaware of it, and corrects that error, then making an equal distribution calls for it to change the secondary holding in Henson to make it comply with Wolf. And that's what should be done in accordance with Walsh as a matter of interpretation. The 4 orders I asked for explicitly find that NRS 280...
You're way over your time.
I'm sorry, if you...
And unless my colleagues have any other questions.
And I think the court takes time.
Thank you, Mr. Willick. Mr. Beller, can you touch on this aspect of the case with the survivor benefits. My understanding is it was raised for the first time in the answering
That
brief.
was- Judge Ochoa, Justice Periguri, actually concluded in one of his, I think there were 3 orders. That
I
there
think
are
it was a
no-
January 2015 order where
Yes.
he addressed the survivor.
And basically, Mr. Willick did not cross appeal on that. So as far as I'm concerned, I mean, to raise it in an opposition, I don't think is proper, I don't think is timely, and I don't think that the body should even consider that as suggested. Not that Justice Hardesty suggested that, but I don't believe this court can even address that at this
Okay,
juncture.
thank you.
Basically, and I am not going to be singing to the choir, and I consider this body the choir, and I'm not going to be lecturing this body on what the law is. The law in the 4 cases this body has promulgated. I think, and we're not talking about fairness or what's equitable, we're talking about what the parties bargained for, because not everything that is bargained for is fair and equitable. And you have to decide whether or not these parties, as raised by Justice Pickering and Saida, bargained for something that is in the MOU.
But you want to keep this real narrow and strictly as to that one little phrase in the memorandum
I
of
will.
understanding.
And,
That's what you're
and
proposing.
notwithstanding what I believe is the distorted interpretation by Mr. Willick, raised by Justice Pickering, what the language actually says, the Quadro will direct the trustee of PERS to pay to each party their proportionate share of the account at the time Eric retires. Now, we know that the party is entitled to a proportionate share based upon what PERS basically says. But what it also says, pay their proportionate share at the time Eric retires. So to me, this is language that was bargained for between the parties. Justice Douglas raised the issue. Mr. Beller showed me, well, in 00067, and I'm reading from the language in the decree, Eric Holyoak has a 457 deferred compensation plan through LVMPD through the Hartford. Tony Holyoak is to receive 1/2 of the value, and here's the language, Justice Douglas, plus an additional $20,000 as of June 30th.
But it doesn't characterize the $20,000. It was indicated that that was her share of the interest in the home in the joint petition, but isn't referenced anywhere else.
No, it says what it says, and there was an additional amount. And again, other than Mr. Holyoak's declaration, which is part of the body, there is nothing that was submitted by Mr. Willick or Tony Holyoak as to what that $20,000 was for. It is
Okay.
my position that that's what it was for. That's what they bargained for.
Okay, thank you. Colleagues, any other questions? Nope. All right, thank you both for your
Very much.
presentations. We appreciate it very much. This case will stand submitted, and we'll stand in recess until 11:30.